I do thank you for giving us a couple of minutes of your time here at Nooga Radio. We argue that you should love your neighbor and buy local. Our theme and our argument every day here at the David Tulis Show is love your neighbor and think in terms of near over far, small over big, and simple over complex. And in the footnotes, where even there the good people fight against you and against me, we insist defiantly that personal is better than corporate and physical than abstract. Brought to you by Nooganomics.com, the website for the man who matters. John Harris is the executive director of the Tennessee Firearms Association and has been fighting for years for the right to bear arms in the way of litigation and also in the context of politics. Politics is an arena in which it's very difficult to get anything true and good to happen. That group is fighting for constitutional carry. And yet it's possible that a lone defendant on appeal could overturn the truly evil and vague statute in Title 39 of the Code, which is the intent to go armed statute. John Harris, say a little bit about the existing state of the law in Tennessee, and then help us see which of the candidates for governor may be closest to ending some of these abuses by political means.
Well, that's a great place to start, and I think people need to understand, your listeners need to embrace the problem that under current Tennessee law, and this comes more from my attorney role as opposed to my executive director role, the statutes in Tennessee fundamentally presume that it's a crime for a citizen to carry a firearm. It's a crime for a citizen to possess a firearm. And the way you come to that conclusion is we have a statute, the one that's at issue in this lawsuit, Tennessee Code Annotated 39-17-1307, makes it a crime that can range from a misdemeanor to a felony, depending on the circumstances, for someone to carry a firearm, quote, with the intent to go armed. Now, that phrase isn't defined. But you get some appreciation for the scope of the definition when you look at the next statute, Tennessee Code Annotated 39-17-1308. And 1308 says it's a defense, not an exception, but it's a defense to a violation of 1307 that the person carrying the firearm was, for example, carrying it and had in their possession a handgun carry permit, or carrying it at home, get that, or carrying it on a piece of land that they own, or carrying it at their place of business, or carrying it while they were hunting or on a gun range or engaged in, quote, other lawful activities. So because all of these things are classified as defenses under Tennessee law, as a technical matter, you could be arrested for carrying a gun on your person at home. You could be charged, you could be put to trial, and one of the defenses that you would have to bear the burden of proving at trial is that you were at home when you engaged in the conduct. Now, if your listener understands that existing Tennessee statutes are written in such a fashion that they completely infringe the rights guaranteed by the Tennessee Constitution and the Second Amendment from the word go, then they can maybe better appreciate the issues and the arguments that this gentleman is raising in his appeal challenging Tennessee Code Annotated 39-17-1307.
And that would be the Jay Hirsch case. Jay, yesterday at the hearing, said that the statute is unconstitutionally vague. It's void for vagueness on account of there being no definitions for words such as carry, John Harris, or intent to go armed. What does intent to go armed mean? Answer that. You're an attorney. What does it mean?
There are some, he's correct. It's not defined in the statutes, okay? There are some Tennessee court opinions, appellate court opinions, which talk about that concept because there have been challenges to it in the past. And the way the courts have come down is they have said that the distinction or the nuance is between someone carrying a firearm, for example, that they've just purchased and they're really transporting it. They've got it in a box or in a bag or in a case of some kind, versus someone transporting a firearm in a state, not necessarily loaded, but in a state where it could be used on short. So, for example, they don't require that the intent to go armed be for criminal purposes, for robbery, assault, murder. They include within the definition intent to go armed, carrying a firearm, for example, for self-defense, even at your own home. You fall into that issue that we talked about previously of crime versus what's a defense to the crime. And so the courts take a very broad, I think, impermissibly so, definition that's pro-law enforcement instead of pro-citizen on what does the phrase intent to go armed mean, and they literally mean, in terms of construing it, if you have any intent to possess the weapon or have it in your vicinity in a condition where it could be used for any purpose, then you have an intent to go armed.
In other words, if you have a gun, and let's say you have a .22 caliber revolver, as Jay Hirsch had in his appeal, and there were bullets in the cylinder, that those bullets show that you were intending to have that weapon there to be used and usable as a weapon, John Harris.
Oh, that's correct, and it's actually much worse than that. I represented a gentleman several years ago here in Nashville. Get this. The facts showed that the guy was in his personal car, which was a four-door sedan. He was driving middle of the morning. It was turkey season. It was legally a season during which you could hunt game. The guy was in camo clothing. He had turkey decoys in the back seat of his car. The only gun in the car was a camo shotgun that was empty. There was no ammunition in it, and it was laying in the floorboard of the back seat. There were 2 or 3 shotgun shells, clearly of the type that you would use for hunting turkey. They were the right composition, laying in the front passenger seat. A Metro police officer stopped this person and charged them with a violation of carrying with intent to go armed. And the position they took was under the definitional statute of an unloaded weapon. An unloaded weapon is a firearm that has no ammunition in the vicinity of it. And the officer's position, and there was case law that backed him up, was because both the firearm and the ammunition were within arm's reach of the driver, that it met the definition of a loaded firearm under Tennessee law. Well, that's nuts. And the evidence showed that there was no intent to be armed, clearly, because, this guy was coming back from a hunting excursion. But yet he gets charged, arrested, put into the criminal court system, has to hire an attorney, and deal with all of this drama, because we have a state statutory scheme that's premised upon the idea that it is fundamentally a crime for your listeners to possess firearms unless they have a valid defense to their possession.
Well, Jay Hirsch is challenging this. He's challenging the constitutionality of the statute. He's saying it is impossible to know when you're obeying it, when you're disobeying it. And then he cites numerous cases in his brief and 1 or 2 cases in the oral arguments yesterday that if you don't know whether that you're violating the statute, you can't have you can't have intent. There has to be, for there to be a crime, there has to be intent. Intent is really impossible to you can't show intent, you can't show knowledge, and so it should be overthrown, he argued, on its face, because it's impossible to, and there are no definitions in the statute, as you point out. That's
a great point for your listeners. it's a fundamental concept of constitutional law that the courts of every state and the United States Supreme Court have affirmed that under our Constitution and the concept of due process, a criminal statute, as distinct from a civil statute, okay? A criminal statute, because it can deprive you of your liberty, deprive you of your freedoms, even deprive you of your life in some instances, must be sufficiently clear that the average person knows what is prohibited activity and what is not. And that doctrine is referred to by the courts as the vagueness doctrine. So when I go talk to people and present this issue to your listeners, for example, this morning, what I tell them is, as a practical matter, the vagueness doctrine, as it was initially developed by the courts, essentially meant that the average person, that the average police officer, the average district attorney, judge, juror, and appellate court could read a statute, and all of them would agree without constrained, English gymnastics, what the statute either allows or prohibits. So that really the only question in a criminal case is, did this person violate that statute or standard? That's the vagueness doctrine in a nutshell. Now, if you look at Tennessee's statutes, particularly the way the Republicans have been band-aiding them for the last 7 years, and frankly for the last 2 decades that I've been involved, what you will see is that there are a number of instances where the legislature has passed laws, and sadly, I submit, because they don't understand the Constitution. It's not that they're not good people, they just don't grasp basic constitutional principles. But they've passed laws that have created for our environment today a set of gun laws that are so convoluted, inconsistent, and patchworked that you can't knowingly, comfortably predict what is and is not unlawful activity.
Well, could you give a
great example?
John, go ahead. Give an example.
If you go back to 2009 and 2010, the legislature passed a law in 2009 that the governor vetoed, and then they overrode the veto, that was intended to allow permit holders to carry in restaurants that served alcohol. And because of the concern of political correctness, the Senate sponsor told me this, the statute in 2009 was written to say that a permit holder could only carry a firearm into a restaurant if 50% or more of its sales were non-alcoholic beverages or products. And that's what passed. And that went almost immediately to the court in Davidson County by a group of anti-gun advocates trying to overthrow the statute. And they succeeded, frankly, in a way that helped gun owners ultimately. Because the court said it was impossible for the average citizen to know, standing at the door of the restaurant, what their volume of alcohol sales were compared to non-alcohol products. And so she declared the statute unconstitutionally vague and struck it down. Well, in 2010, the General Assembly came back, and their solution was, we're just going to entirely repeal the statute that prohibits possession of firearms in places where alcoholic beverages are served. Well, that's what they should have done in the first place, but they didn't.
Well, tell John Harris of the Tennessee Firearms Association, by the way, that's TennesseeFirearms.com, TennesseeFirearms.com if you want to find out more about the TFA. Give my listener an example of a trap. Put my listener in a situation, let's say my gun-wearing, gun-carrying listener who cares very much about innocent children and women and wants to be able protect them, protect himself if there is let's say a shooting, killing incident in his vicinity. what an example of a trap that the statutes that we now have give for such a person? Show how fanged the terrain is today, John Harris.
Well, yeah, okay. I can give you two examples. One, almost everybody's going to run into. We have a state statute that came on the books in 2008 that says all state parks, all local parks, as a result of a 2015 amendment, and all federal parks, to the extent not otherwise regulated by the federal government, are locations where handgun permit holders can carry their firearms with them, okay? So public parks, statewide, are fair game, permit holders can go in there. Now, if you don't have a handgun permit, you can't carry a gun in a park. That's still illegal, but you can with a permit. Well, the Republicans, in messing this up yet once again, not knowing what they're doing and trying to be politically correct, they left this language and intentionally changed parts of it that says, if a school is using any portion of a park for recreational purposes, so you've got a school club, say, or team that's in the park for golf or cross country or lacrosse or soccer, any kind of recreational activities, that the permit holder, if they knew or should have known the school was using the park for recreational activities, could be charged with a Class E felony, because the minute the school enters the park and until it leaves the park, the statutes, the way the Republicans have written them and passed them, says that the school's entry morphs the park, the public park, into school grounds, the entire park. And so you could be picnicking or on a hiking trail, and if you knew that every Thursday, or that this particular Thursday or Friday or Saturday morning, the school was having a cross-country meet, if you were in the park and knew that, you committed a Class E felony. Well, that's a trap. There's no reason for that. And it's so bad that there's an Attorney General's opinion that says, for purposes of the statute, now they may have amended this out or addressed it in 2015, but for a period of time, the AG said, if the school even stores equipment in the park, that constitutes a use which triggers the morphing into school grounds. So it could be a public park that the statute says you can carry in, but that because of the use of the school would be a Class E felony violation 24 hours a day, 7 days a week.
This is David Tulis, and we're talking with John Harris from the Tennessee Firearms Association. He's the executive director. That's TennesseeFirearms.com, TennesseeFirearms.com. John, is there anything special happening in the way of efforts giving? Do you have any kind of gun giveaways going on right now, or anything special at the association?
Yes. Right
Recruiting
now,
efforts?
The Tennessee Firearms Association is really focused on the 2018 elections. In 2010, Bill Haslam promised us, and it's on our website, if you want to do TennesseeFirearms.com/Haslam, Haslam, you'll see it. He promised our membership that if he was elected governor, he would sign into law constitutional carry if that bill was put on his desk. For the last 7 years, Bill Haslam and his administration have bent over backwards through Beth Harwell and the Senate leadership to make sure that constitutional carry bills and permitless open carry bills, such as the one sponsored by Senator Beavers, Senator Green, Senator Roberts, Representatives Matheny, Van Huss, Womack, and others. He's been over, Governor Haslam's been over backwards to make sure those bills die in subcommittees, that they never even get to the floor for a vote or a debate, much less enacted, so that he's got to deal with them on his desk. So we're really focused right now on the 2018 election and our big fundraiser for that purpose, specifically for that purpose, raising funds for the election fund.
We'll be right back. We're talking with John Harris. This is David Tulis. We're at Nooga Radio, and we're finding out more about the right to bear arms and the chief lobby, the chief defense of firearms rights in Tennessee is the TFA, the Tennessee Firearms Association. We'll have more, but now I've got some important messages. This is David Tulis. We're brought to you by Nooganomics.com, Nooganomics.com.
The Tennessee Valley's news, talk, and sports leader, Nooga Radio, AM 12.